Good morning, everybody. It's a pleasure to be here today to present this presentation on designs. The topic that we're going to discuss, next slide, please, is redefining the industrial design landscape, issues and challenges in the industrial design protection in the EU and C. So in this context, we're looking more detail of what was already touched on yesterday by DG Grow in the context of designs. So what would I like to present today? I will give a quick background on what we consider as designs within the EU. I will quickly touch on statistics, and then we will get into the meat of the subject. In this case, we will provide some more detailed information on the evaluation that was carried out by the Commission. And with the findings of that result, we will draw the conclusions that are being put together now while the EU Commission is preparing new regulations for the designs. Okay, within the EU, we have a very clear and concise definition of what a design is. In fact, in this case, I've simply copied it from the article. So the appearance of a whole or part of a product resulting from the features in particular lines, contours, colors, shape, texture, materials of the product itself, or ornamentation. So what does this mean in practice? Basically, a design represents what a product looks like. Now, why would people invest in designs? We have carried out a study together with the IPKey here in Europe, looking at the ownership in general of IP rights. We have evaluated the results of being an owner in terms of number of employees, the revenue, and the wages. In our case, in designs, what we see in the chart is essentially design owners or companies that own designs in general are larger companies to the extent of 5 times greater than a standard company. Also, the revenue can be 32% higher than a company without these designs protected. And finally, higher wages in the region of 30%, which of course, as we all know, is a very important element trying to attract talent into this innovative area. So within the EU, where can you protect a design? First of all, you can protect it in the national offices. So protection in each member state are the Benelux, which is a combination of 3 member states. And that protection lasts for 5 years and is renewable up to 25 years. We also have what we term the unregistered community design. This gives you complete coverage throughout the EU, and one needs to present their design to the public, and there is therefore no need to actually register. Period for protection is a maximum of 3 years. Then finally, we have the registered design, where users, applicants can come to this office, the EU IPO, and register their design for, again, a period of 5 years and renewable up to 25 years. And in 2008, we joined the Hague Agreement, allowing other applicants to come via the WIPO to seek protection for what we term the international registered community design. And again, that's up to 25 years. So that's how people get the protection. Okay, so what is the actual scope of protection that is covered within the EU? Well, the design itself. So the design features of the product which are visible, i.e. what the design actually looks like. But what is not part of the scope of protection? First of all, the indication of product is not part of the scope. Neither is the description or the classification of the product. And that's an important element to bear in mind when we look at the evaluation that was performed.
So according to this definition, this is the first technology to register and keep track of the IP right.
First of all and foremost, is it compliant with the definition of a design? i.e. can we see a product? Does it conform with the public policy and accepted principles of morality? And finally, in the case of having a multiple application, which is where the applicant is applying for more than one design within an application, they must, under today's rule, respect what we term as the unity of class. That is, that all of the designs within that application must belong to the same Locarno class. There is an advantage for applicants to send a multiple application, as the fees are reduced steadily as the number of designs are contained in the application itself. Now, what do we not do as part of examination? We don't check the absolute requirements, i.e., we do not check for the novelty, the individual character, the visibility, the technical function, or designs of interconnections. This is important, of course, for us, as it speeds up the examination of the applications greatly, to the point that today the office is able to examine an application in many cases in a matter of hours, but certainly no more than a few days. What is not checked additional are the earlier rights, or whether the applicant is entitled to the design. So in a nutshell, we focus very much on the core subject, on the definition of the design itself, and whether we can see, when they send in the application, an actual design. So where has that left us over the last few years? As we can see, the office was proud last year to have reached 1.5 million designs, which is certainly a very impressive threshold. These designs mainly are filed directly to the office, but also in the orange on this, or in the gray on the slide, you will see there is a gradual interest to send applications via the whiteboard. We also determine the type of application somebody can send. So we have what's known as fast track and regular track. Fast track can be sent, and we guarantee that it will be registered, assuming there's no objections, within 2 days, whereas regular track will take up to 9 days. On average, normally it takes 4 or 5 days. In 2021, we did receive a total of 115,000 designs, 100,000 coming directly and 15,000 via the whiteboard. So how does this compare to the national offices? You will see here in the chart, the blue represents the total that are received by each of the national offices or member states of the EU, while the orange represents the community design. You will see that we are working very much in harmonization, in that the national offices are still very much busy, follow not exactly the same trend, but certainly we are working very much at the same pace together. So the source of applications, the source, fine, not to be expected. A large amount is coming from the EU and then the States, and now certainly in recent years, China, who is beginning to be outside the EU, our largest filer. Again, we have Japan and then other countries. So now we're coming to the evaluation that was performed by the European Commission in order to ascertain if the design legislation and protection provided is fit for purpose for today's need. I remind you that the legislation is almost maybe about 18 years old at this point. What were they looking for? They were looking to determine the efficiency, the effectiveness, the relevance, the coherence, and the added value of the existing system. And as I've said earlier, to see if it's still fit for purpose. This evaluation report was finalized at the end of 2020. So overall, after consulting a large number of stakeholders, as you can see on the right, these included the owners, the users, SMEs as a special part, advisors, authorities, researchers, and others. And what we see is, in general, a very positive result that 75% of all of these stakeholders consider the system works well. What we can highlight overall in the area of users, the result is somewhat lower than the average. We will look at this a little bit further in the conclusions. Now, what did we ask? We asked, was the registration simple? Yes, very positive result. Affordable? Yes. Promote innovation within the EU? Yes. Accessible? Yes. Preventing counterfeiting? Yes, somewhat less, but still a very good result. Same protection across the EU, 80%. Again, good result, but certainly going down compared to the previous categories. And then finally, we look at the products circulate more freely. That's good. Something certainly part of the EU in itself and the harmonized market, and that products should be able to circulate freely. So this is an important outcome. And then finally, serving all industrial sectors. Here we see we have reached 65%. This can be largely accounted for from the lack of consistent coverage in the component parts, which is not covered, let's say, adequately in today's legislation. So that's the general survey results per area. So now let's look at the added value in more detail. So the added value, as far as most of our users are concerned, or our stakeholders, is the simplified registration. Also, the legal certainty that it provides. And finally, the prevention or at least reduction of counterfeiting activities across the EU. So these are important elements that have been the successful part of the current legislation. Okay, but what were the shortcomings? Because at the end of the day, this was an evaluation, and we're trying to determine in what area can we build upon the existing legislation. So shortcomings in the EU, so harmonization of the representation requirements. This refers to the difference between the representation and how it's presented, maybe to our office or the member states. In there are small differences. Again, harmonization of the product indication and the potential scope for protection. Again, it's competing maybe between the member states and the EU. To adapt for the digital and green transition. Today, it was, yesterday rather, it was mentioned about certainly the digital transition and how the new types of designs in the virtual world, in the icons, the dynamic views, how are these covered? And again, in the same with the green transition that we're all embarking on. And to repeat, finally, again, one of the important elements that is known and certainly recorded was the coverage for spare parts protection. This needs more attention. The limited utility of the description was mentioned by some people, and then the relevance, the scope of the relevant exhibition priority. In this case, today, there are 5 well-known exhibitions in which if you present your design, we can provide exhibition priority. There are, let's say, this comment is, could we enlarge the number of exhibitions that could be included in order to attain this right? Okay, so taking the added value, taking the overall findings, how do we look at a holistic level at the legislation as it is today? So is it relevant? Well, in general, consideration is, yes, it has made a substantial contribution to the EU economy and the growing value of technological designs for EU innovation. In this case, the steady number of design applications filed with the EWIPO proves both the success of the community design and the rising importance of companies give to protecting their designs. The awareness. Here, the design protection system may be underused, in part due to a lack of awareness. This is important, as you saw earlier on, with the users found there were some things missing with our system. This seems to be around the overall awareness. So we need to work harder in this particular area. So fit. So the legislation's not fully adapted, as we've seen, for the digital age. For example, graphical user interfaces, icons, dynamic views, private use limitation in the context of 3D printing. So these are areas that we would like to move into further. Okay, the effectiveness. In general, yes, it is considered it has been broadly effective, allowing people to move their products across the single market, with the exception, again, of component parts that kept coming up as something that needed to be addressed. So in this case, it's due to only partial harmonization. The economically important spare parts market continues to be fragmented today, causing considerable legal uncertainty and distorting competition. In the area of efficiency, right, the unitary registration system, i.e., one application that covers the entire EU, has lowered the registration costs, less complexity, and fewer delays in design registration. Some aspects of such representation requirements, filing multiple applications on fee structure, could be further improved. In this case, what this refers to is the restriction we have in the case of multiple applications that they have to respect the unity of class. So this now is under consideration. So the coherence. So what do we mean by the coherence? The evaluation also revealed that the procedural rules of the member states differ from each other and from the regulation. That is, that we do still have differences between how we protect designs in this office, in the EU IPO, and the member states. And we would like to begin to address that. These differences clearly have a negative impact on the coherence of the system as a whole. And for example, which is interesting, we have recently reformed the trademark regulation. And in fact, due to that, to the recent trademark reform significantly increased this incoherence with the legislation on design protection due to the further substantive and procedural harmonization in the trademark sector. What do we mean in practice here? This is to cover counterfeit goods in transit or administrative invalidity procedures, i.e., we need more harmonization with the designs in order to cross frontiers within the EU. And then finally, the added value. Clearly, the whole concept behind designs and aligning the systems both at the EU level and with our member states was to create the harmonization of the internal market, allowing goods to move freely across the EU itself and allow those applicants feel confident with the protection that they are provided with. Taking all of this together, yes, it has been agreed that the legislation that is in place today does broadly fit the needs of the EU and the member states and the internal market. However, there are areas for improvement, which are currently, as I've said, under consideration with the EU Commission today in looking at the future regulation for the designs. Right. The evaluation reveals, again, the relevant shortcomings that need to be addressed in order to make it fit for purpose. So again, the twin digital and green transitions we need to address, and to become substantially more accessible and efficient for industries, SMEs, and individual designers. What do we mean here? We mean we need to work on the awareness of what a design is, what are the benefits of the design, what indeed are the differences between design protection and perhaps protection that may be provided either by trademarks or by copyright. So more work needs to be done here, and that is at least the plan. The shortcomings in many ways also in outdated or overly complicated procedures, as it was considered, inappropriate fee levels and fee structures, and the coherence between the member states and the EU, particularly in the single market for spare parts, will be an essential part of this new legislation. So with that, that is the end of the presentation. I hope it was clear. What I can say is, in general, certainly the design application, design protection here within the EU is very healthy. It continues to increase every year, and we need to work further on the awareness. And once the new legislation comes into place, we will see how we deal with the component parts, which certainly will be a challenge.
Thank you very much, Eamonn. Just one question for now. Is there a time frame for the completion of the design amendment? Would
Uh,
you know?
Well, let's say there's no fixed time frame. What we do expect, which was touched on a bit yesterday, either by the end of this year, early next year, we do expect the regulations to be complete. But after that, then we have to do the implementing regulations. So possibly in the scope of 2 years when it'll actually reach the marketplace to seek the new protections.
Thank you very much. Okay.
Thank you.
If there are any further questions, I will read them later on towards the end of the webinar. Thank you
Thank
very
you.
much.
It was a pleasure.
Eamonn.